So, as per the questions relating to Hindu Succession Act 1956, we found certain common questions are set, and that is regarding the heirs falling under class 1 of the schedule, then the agnates and cognates, then the rule of survivorship, rule of succession, and the rule of preference, and the general rule of succession, and the very doctrine applied for rule of distribution, and the very new concept relating to Hindu women's right to property. So also, what is co-partitionary property and who is a co-partitioner, and also the very important amendment made in 2005 which brought a substantial change in the co-partitionary nature of the property and the very share among the heirs. So, out of all these questions, these are the common questions asked, and to explain that, one thing, who are the agnates and what exactly agnate means? A person related to wholly through male, either by blood or by adoption, and such relations are father's brother or father's brother's son or father's son's son or father's son's daughter are considered as agnates. And if you will go to cognate, and it means a person related not wholly through males but through females, and such relations are son's daughter's son, son's daughter's daughter, sister's son or daughter, or mother's brother's son, all are considered as cognates. So also regarding those heirs and into the very question of intest succession, the very co-partitionary property here means the ancestral property. And regarding that, there are two rules are applied. One is rule of survivorship and rule of succession regarding the very devolution of property, and whereas rule of survivorship applied with respect to co-partitionary property, which is an ancestral property, and the rule of succession is applied to property held as separate or self acquired property. And so also the very question of heirs, and there are four legal heirs of a male Hindu who dies intest, and they are the relatives of in class 1, relatives in class 2, and the cognates and agnates. So, the very rule of order of succession in class 1 and class 2 of this schedule And as regarding the relatives mentioned in class 1 of the schedule, succeed or inherit simultaneously and with an equal share. And in case of class 2, heirs, the rule of preference is applicable. And this means heirs in first entry shall be preferred to the second entry, and those in second entry shall be preferred to those in third entry, and so on in succession. And regarding to clarify this very rule of preference, the very order of succession, it includes, suppose son, then it includes natural son, posthumous son, and adopted son. But here it excludes illegitimate son and stepson. And regarding daughter, here means all married or unmarried natural daughters, adopted daughter, and posthumous daughter. But it excludes adoptive mother. But a stepmother is not entitled. So in this list, besides the above three, the widow of a predeceased son, or son of a predeceased daughter, daughters of a predeceased son, daughter of a predeceased daughter, daughter of a predeceased son of a predeceased son, or other legal heirs. So, this is regarding rule of preference, and where this also another aspect that is found regarding the very roles of distribution of the property among the heirs in class 1. And there are particularly 4 different rules applied regarding distribution of property among the legal heirs of class 1. So, exactly rule 1 expect the widow, or if more than one, shall take one share. And rule 2 expresses that sons, daughters, and the mother shall each take one share. And rule 3 explains that heirs of each predeceased son or each predeceased daughter shall take between them one share. And regarding rule 4, in the question of distribution of property among the heirs in class 1, the very distribution referred under rules 3 shall be so made that his widow, surviving sons and daughters all will get equal portion. So these are the provisions relating to rule of distribution. And when we go to the entries of heirs in class 2 of this schedule, and there we found the father, sons, daughter, son, sons, daughter, daughter, brother and sister. So daughter, son, sons, daughter, sons, daughter, daughters, daughter, son, daughters, daughters, daughter. So also the father's brother, father's sister, mother's father, mother's mother, mother's brother, and mother's sisters are found in the entries in class 2 of the heirs. So, the very question of succession among the agnates and cognates on the basis of rule of preference are provided as under Rule 1, Rule 2, and Rule 3, and that all we found under Section 12 of the Act, and that also in among the agnates, both in ascending line of succession, so also on the descending line of succession among the male who died intest, so also among the females relatives of such female dying intest, we found both the ascending order and so also the descending order of inheritance, and that also as being governed under rule of survivorship, rule of succession, and rule of preference, and also under the very rule of distribution. And as to the very important concept regarding Hindu women's right to property, and as it was provided under Section 14 of the Parent Act, and that is Hindu Succession Act 1956, and subsequently the very amendment of 2005, how it brought a substantial change regarding the right of both either the married or the unmarried daughters on the properties of their parents dying intest, and that aspect and that amendment of 2005 brought a radical and substantial change, which you could say the very fundamentals of Hindu succession is completely revolutionized and changed the very nature of inheritance regarding proportionary property, and now how the very daughter, either married or unmarried, is considered legally as a copartner on the very copartnerary property of her parents, and regarding that the very provision of Section 14, which provides the Hindu woman's right to property, and under the very subsection 1, she would be held as the full owner and of both movable and immovable properties acquired under inheritance or at petition or in lieu of maintenance or by gift at or after marriage or by purchase or by her own skill. And regarding all these relating to Hindu women's right to property as provided under subsection 1 and also subsection 2 provide that a female Hindu does not become absolute owner of the property acquired by gifts, will, or any other instrument. And regarding that, the very amendment of 2005 is relevant, and that aspect we would like to discuss in our next upcoming video.